welcome to the second in a series of webinars organized by the European branch of the Chartered Institute of Arbitrators on how different national laws regulate certain fundamental issues in arbitration. The previous webinar of the series, moderated by the chair of the European branch, Philip Landolt, focused on corporate law. The next one will address the topic of the party-arbitrator relationship. Today is on arbitrability of disputes. And then subsequent webinars will address practice relating to oral hearings, interim measures, and the recognition and enforcement of awards. These seminars will be recorded and will remain available on the FCIArb platforms. In this seminar, we will be comparing approaches in Germany, Greece, Lithuania, Italy, Poland, Russia, and Spain. And the webinar is intended to be a guide rather than an interactive discussion. Therefore, there will be not much room for questions. We may only discuss a few at the end of the presentations, and you're invited to submit your questions in the Q&A section. And if some questions cannot be answered, I'm sure that the speakers will be happy to receive questions through direct contact with them. Each of the distinguished speakers will report on the approach taken in a particular state. I will briefly introduce the speakers before giving them the floor, while you may find additional information about them in the biographies that I have already posted in the chat room. With regard to arbitrability, it is important to note that there are matters that cannot be settled by arbitration, or in a more appropriate wording, are not capable of being settled by arbitration. Thus, arbitrability means the possibility to settle certain matters by arbitration. How to find out if a matter is arbitrable? Is there an easy answer to that question? The answer is not easy, because the concept of arbitrability, even for international disputes, is defined at domestic level by each state. Each state decides which disputes may be resolved by arbitration and which may not. This is the reason why it is useful, if not necessary, to understand the different approaches by different states. And why is that necessary? Because an arbitration on a dispute that cannot be arbitrated can be ineffective or unenforceable. Then there is another complexity, and let me give you a practical example. Under an exclusive distributorship agreement, the parties, distributor and manufacturer, agree to settle the dispute by arbitration. That arbitration agreement may be perfectly valid under the law applicable to the arbitration agreement. But that matter could be not arbitrable under the law of the seat of the arbitration or under the law of the state where the award is to be recognized and enforced. Therefore, the check on arbitrability of disputes must be carried out at 3 different levels. 1, the national law governing the arbitration agreement. 2, the national law of the seat of the arbitration. And 3, the national law of the place where the recognition and enforcement of the award is sought. And finally, in each state, the concept of arbitrability may vary over time. In the United States, for example, before the Mitsubishi case decided in 1985, antitrust issues were not arbitrable. Then the Supreme Court in Mitsubishi reversed the principle and decided that the antitrust issues could be arbitrated. Another example, the European Union has recently ruled that disputes on a certain type of direct intra-EU investments are not arbitrable. That is referred to as the ACMEA jurisprudence, and there are other closely related cases like the Mikula case, for which, by the way, the last October 2, 2024, the EU General Court has issued another important decision on this trend. So in a nutshell, arbitrability is a developing principle, and arbitrability changes from one state to another. So now we may start the comparative examination. And let me say that some states define arbitrability at the statutory level. Some other do not define arbitrability, which may then be determined on the basis of case law. That is the case, for example, for English law. So the first question to the speakers is how your national law delimits arbitrability of disputes. And the question will be posed in turn to all the speakers, and I would start with Reinmar. Reinmar Wolff is an assistant professor at the University of Marburg in Germany, and a practicing lawyer who regularly sits as an arbitrator in both institutional and ad hoc proceedings. He is also a fellow of the Chartered Institute of Arbitrators. Reinmar, do you have a statutory provision in your country to define arbitrability?
Yes, thank you. So let me start by saying it's a pleasure for me and an honor to be here and to contribute on the German perspective on arbitrability. And the answer is relatively easy and straightforward for Germany. We indeed have a statutory provision in 1030 of our Code for Civil Procedure.
Thank you, Reinmar. So you have the provision contained in your Code of Civil Procedure. Okay.
As the entire arbitration law for historical reasons is contained in the Code of Civil Procedure in Germany. Okay, good to know. We have then Gailė from Juozapaitytė. Sorry for my pronunciation. Maybe Gailė, you can repeat your name with the right pronunciation. And Gailė is an assistant partner at TGS Baltic in Vilnius. She specialized in the energy sector
energy litigation, and international arbitration, including investment arbitration. Gailė, which is the situation in your country?
Yes, so first I would say that Lithuanians are known for complicated last names, so Juozapaitytė. In Lithuania, and similar to Germany, we have a statutory provision in the specific law dedicated to commercial arbitration. So the law on commercial arbitration is called. And Article 12 establishes matters of arbitrability, and the wording remained the same since 2012.
Good, thank you. Roberto for Italy. Roberto Oliva is a partner at the Dispute Resolution Department of Pavia e Ansaldo, an international law firm with the main office in Milan and other offices around the world. He is also the honorary secretary of the European branch. Roberto, which is the situation in Italy?
Oh, thank you, Jacopo. Italy also has express provisions addressing the issue of arbitrability. The first one and the more relevant one is Article 806 of the Italian Code of Civil Procedure, whereby the parties may refer to arbitration the decision of disputes which have arisen between them when the subject matter does not concern rights which may not dispose of. But there are also other provisions which are of interest. The first one is Article 808 bis of the Italian Code of Civil Procedure, stating that by entering a specific agreement, the parties may establish that future disputes relating to one or more determined non-contractual relations be decided by arbitrators. So this provision is also saying that disputes concerning non-contractual matters are or could be arbitrable. And eventually, the last provision I would like to mention is Article 838 bis of the Italian Code of Civil Procedure that concern the arbitrability of corporate disputes.
Thank you, Roberto. And we will be discussing the content of these different provisions during the second turn of questions. And so I would like now to know the law in Poland. Krzywosz, okay, is an experienced arbitrator with more than 15 years of experience in commercial arbitration, and Shenko is also a chartered arbitrator of the FCIArb. Shenko.
Thank you, Jacopo, and thanks very much for the invitation. It's a pleasure to be here. As far as the question is concerned, the situation is, as Reinmar said, pretty straightforward. We have the Civil Procedure Code with the separate section which is devoted to the arbitration. It's just a single regulation, so we have no separation between the international and the local or domestic arbitration. And Article 1157 sets what is arbitrable under the Polish law.
Good, very, very helpful. Natalia from Spain. Natalia, no, sorry, yes, I have it here. Yes, Natalia Gulyaeva from Germany. Natalia is based in Germany, but she's qualified in England and Wales, Germany and Russia. And Natalia, probably you can tell us the situation in Russia, where there are also some pending important litigations. Is there a source to define arbitrability in Russia?
I did with pleasure, and I also would like to add that it's a real honor to be a part of this webinar. There are, like in other countries, statutory provisions from the codes. Key codes are the Civil Procedure Code and the Arbitrage Procedure Code. This is the code used for the proceedings before the state commercial courts. Plus, in addition to that, there is law on arbitration courts covering domestic disputes, domestic arbitration, and the law on international commercial arbitration, which addresses international commercial arbitration. So 4 sources.
4 sources. Very, very clear. Thank you, Natalia. Then we go to Spain, or probably better to the Iberian Peninsula. Nazareth Romero is a partner at Ovoli Romero Abogados, a law firm with offices in Madrid, Rome, and New Delhi. And Nazareth is also the chair of the Iberian chapter of the European branch. Nazareth, over to you.
Thank you very much, Jacopo. It's an honor being here. Let me a little brief as Iberian chapter Europe branch. Arbitrability in Spain is a monistic system which is established in our Spanish Arbitration Act 2003, with the reforms regarding in 2011, which is included in our current Arbitration Act Law 16 2003. Also, I would like to remark briefly that we are back-to-back UNCITRAL Model Law 1985, and also Andorra and Portugal is based on UNCITRAL Model Law. As you can see in the screen, Andorra is the younger because it's in 2014. Portugal is in 2011. Also, I would like to remark that the principle of arbitrability in our monistic system is established in Article 1 and Article 2. The principle of arbitrability is provided that all the matters free disposal by the parties are arbitrable, and is in connection with our constitution, Spanish constitution, which is established in Article 24, and nowadays is based on Article 10 of our constitution, that is established the supreme will of the parties which are established in a contract. Thank you.
Very clear, Nazareth. Thank you very much. And so now we can get into the core of this seminar. We go to a second question, which is what is arbitrable and what is not arbitrable under the law of your state. I would ask you just to make reference to the provision that defines arbitrability in your country. And after that, I will be asking for different particular subject matters, if they are arbitrable or not. So now I'd ask you to give the general principles. I'm going to share on the screen a table that displays what the situation is in the different states. And I would start with Roberto, because Roberto has to leave us for some minutes at 10:30, if I'm not wrong. And Roberto already mentioned briefly which is the situation in Italy. So Roberto, you go ahead.
Thank you, Jacopo. I would say that there is a great divide between European arbitration laws. More liberal laws allow arbitration for all matters involving an economic interest, while more conservative laws allow arbitration only for matters concerning rights of which the parties may dispose by contract. And Italian law is among the more conservative jurisdictions. So arbitration, as a general rule, is only allowed for matters where the parties may dispose of the rights in dispute by a contract. And I would say that taking into account the construction and the pro-arbitration attitude of Italian courts, this does not create any significant difference compared to more liberal jurisdictions, with the exception of one area which is really relevant now. In jurisdictions like Italy, where arbitrability depends on the parties' capacity to dispose of their rights, there is room to maintain that disputes where trade sanctions are stake are not arbitrable. It's a very complex topic, and we address it during our annual conference in Copenhagen. So I think that it's not appropriate to delve into it now and to leave space to the other speakers.
Okay, Roberto, you correctly mentioned that there can be a more liberal approach or a more restrictive or conservative approach. I would like to mention what the antitrust model law states. That's a very, very wide and liberal approach, because the model law states that the parties can submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. That is very, very wide, and that is an example of a very liberal approach, which is the case also in Switzerland, for example. Now we can switch to Reinmar. Reinmar, could you please tell us the content of the provision that you mentioned earlier? Thanks.
Yes, of course. Thank you. So Germany indeed belongs to the liberal countries when it comes to arbitrability, and that was actually on purpose in 1998 when the arbitration law was amended to increase competitiveness of German sea. And the provision in 1030 is threefold. In its first paragraph, there is the general rule, and that distinguishes between claims involving property rights and other claims. For other claims, they are arbitrable only to the extent that the parties can settle the dispute. Claims involving property rights are arbitrable regardless of whether or not the parties can settle the dispute. So all claims involving property rights can be are arbitrable. The second paragraph relates to tenancy disputes. That doesn't play a role in practice at all. This is a specific question of consumer arbitration that just doesn't exist in Germany. And the third paragraph refers to other legal provisions outside the arbitration law that may also define matters as non-arbitrable. But again, they are pretty rare. We'll come to that later. Thank you.
Thank you very much, Reinmar. And now I will switch to Greece. Stelios Gregoriou has joined us. We are waiting for him. Stelios Gregoriou is a Greek lawyer and an LLM graduate from the London School of Economics, and currently is based in Athens in Greece, and is very active in arbitration, and is also a fellow of the Chartered Institute of Arbitrators. Stelios, so you were not here for the first round of questions. Could you please tell us which is the source in your country to define, to delimit arbitrability, and then the content of that source? Thanks.
Thank you, Mr. President. In Greece, it was adopted in 2023, 1 year before, a new international arbitration law, which defines arbitrability in a very simple and frugal way, but is trying to cover all potential aspects of arbitrability. So if you can read in Article 3, Paragraph 4, it's a blanket clause, as we can say in wide terms. Any dispute may be submitted to arbitration unless prohibited by law. That way, everything can be referred to arbitration proceedings unless it is explicitly prohibited. And we can say that we have some explicit regulations, like in family law or in some aspects of administrative law, but we can analyze further this issue. And the last remark is that Greek law is dualistic law, so we have a sort of dichotomy, which is not, it is a sort of imperfection of the new Greek law, leaving the domestic law under much more strict formulations, and the arbitrability is much more strict sensu, covering all of these issues. But on the contrary, the new international arbitration legislation is much more ample. And there is a clause here, the legislator trying to close the gap between domestic and international arbitration, inserted a clause saying that domestic parties can apply the international arbitration law as if it were domestic law. So that way, some rigidities of the domestic law can be circumvented. Thank you.
I see. Thank you, Stelios. Now we go to Lithuania, and Gailė will illustrate us what happens there. Gailė.
Thank you. Yes, so Lithuanian arbitration law follows very closely the universal model law. So in turn, we have very permissive approach to arbitrability. And similar as was just discussed by Stelios, the first clause of Article 12 of our arbitration law is a blanket clause that any and all disputes can be arbitrable unless it falls under one of the exceptions listed. We will discuss, I guess, the exceptions in detail in the subsequent questions, but I also wanted to mention that Lithuanian courts have a extensive practice saying that the exceptions cannot be interpreted broadly. So it's very much pro-arbitrability approach, and the exceptions that are listed are interpreted as narrowly as possible by Lithuanian courts.
Thank you, Gailė. We heard from Roberto for Italy. Now it's Poland's turn, and Czenko, please.
Okay, thanks very much. So generally, our arbitration regulation is also pretty wide. It is saying that practically everything that is not restricted by the other regulations could be arbitrable. However, of course, you need to take into account in this sense restrictions which are laid down in the other regulations. The principle is that everything that is, any dispute that is related to the property rights is arbitrable, except for alimony cases. And this is interesting because this is one exception which is specifically defined in this clause. All others, in fact, are related to the different regulations. So this is to remember. And second, if we are talking about the disputes concerning non-property rights, again, they could be disputed, they could be subject to arbitration if they could be settled as the settlement before the Polish court. And again, here, settlement is pretty wide. The restriction is that any settlement which is against the law, which is related to the avoidance of law, or what we call the social rules, will not be valid. So these are just a kind of the soft element which needs to be considered on the case-by-case basis.
I see. Thank you, Shenko.
Thanks.
Natalia, could you tell us something about Russia, please?
With pleasure. Nowadays, the vast majority of scholars uphold the so-called mixed theory of the arbitration clause, according to which the arbitration clause has both procedural and contractual features. And even so, the main effects of an arbitration clause are of jurisdictional procedural character. The clause itself has primarily a contractual basis, being a manifestation of a party autonomy and the result of the party's consent. The general criterion for determining the arbitrability of a dispute is the nature of the legal relations in dispute. That thus a dispute may be arbitrated if it arises out of civil legal relations and the law does not expressly prohibit arbitration of such a dispute. It follows that non-arbitrability of a dispute is an exception, not a general rule. Nevertheless, Russian court practice has developed the concept of concentration of public element, which has allowed some courts to limit arbitrability of disputes, even in the absence of an express prohibition in the law. And according to this concept, the presence of public elements in that dispute changes the civil law nature of the relationship and excludes the arbitrability of such disputes. And I understand we will be commenting on particular types of disputes later on.
Yeah, you're right. Okay, thank you, Natalia. And now we go to Spain, and Nazareth will tell us.
Yes,
Thank you.
yes, thank you, Jacopo.
Probably you have to share the screen. Let me. Would you like to share your screen? Because
if it is possible.
Yes. So let me interrupt my sharing.
I would like to say, meanwhile, that
Okay,
Spanish.
You can upload your documents.
Thank you. I would like to say two things. First, we did with the wait a moment. With the contribution of my steering committee friends, Stefan Reiting, Fernando Mesías, and José Jareño y Sonsoles Moreno, please. And mention arbitration in Spain. Let me a moment, I arrive. Definition of arbitrability, I would like to remark two things. Free disposal of the parties, o sea, is this important parties' will? And second, we are a territorial, not a personal-based law. Spanish law 6023, 2003, is based free disposal, territorial, monistic system, and under Spanish Arbitration Act, arbitration is permissible for any dispute involving rights that parties can free dispose. This means that commercial disputes are typical arbitrable. Back-to-back model law as it is established in Article 1 of the Spanish Arbitration Act. This act will apply to domestic and international arbitration conducted on Spanish soil without prejudice to the provisions established in international treaties by application of 96 Constitution, Spanish constitutions. Which conflicts are or free disposal, all matters of a patrimonial nature, conflicts of economic content that fall within the scope of the parties' power of disposal can be submitted to arbitration. And this consensus of arbitrability exclude marital status, capacity to act, marriage, except all economic concern of the family matters. Consensus exclude also minors and matters, any matter that cannot be wide settled or acquis or prosecution intervention. Thank you.
Thank you. Thank you, Nazareth. Okay, sorry, some housekeeping. The participants are asking to see the bios of the speakers and the comparative table because probably they can't see it in the chat room. Let me say that these two documents can be sent via email to all the attendees. Now, as I said, I would like to go through a certain list of particular subject matters to understand if those very subject matters are arbitrable in under the law of your country. Some of you have already mentioned some of these subject matters, so the answer can be yes or no. But let's start with the first question, and I would start with Natalia because I know Natalia has to leave soon. So, Natalia, I would like to ask you if under Russian law, IT and IP disputes are arbitrable. And I'm starting with you because that's your subject matter. You are specialized on this kind of disputes, so it could be very interesting to know what you have to say.
It's a pleasure to comment, and indeed, this is the area of my focus. Therefore, I'm happy to provide an even broader perspective than just Russia. So technology, data, IP, IT dispute, they might be arbitrable. And since the time is limited, I would give an example based on technology patent disputes. The straightforward scenario, of course, is when a patent dispute is contractual and the relevant agreement includes a proper arbitration clause. This is the case when patent disputes arise out of, for example, a patent license agreement or collaboration agreement aimed at joint technology development, or a R&D agreement where the parties have agreed to a specific allocation of rights to foreground technology. One type of patent dispute that has been increasingly brought to arbitration in this category are those arising out of licensing of standard essential patents on fair, reasonable, and non-discriminatory terms. It's so-called front. And more difficult is the situation when the parties would like to arbitrate a patent dispute concerning patent infringement and patent validity issues. In practice, this might be possible, for example, when the arbitration is based on a submission agreement concluded by the parties after the dispute has arisen. However, various jurisdictions still recognize the exclusive jurisdiction of national courts, for example, specialized IP courts, or administrative institutions such as patent offices for disputes relating to their IP rights, including patent rights. The arbitrability of some patent disputes may therefore be excluded, for example, patent validity disputes in Austria or Sweden, or recognized with inter partes effect only. And this is the case in the UK, France, Australia, or Germany. In the latter scenario, the arbitral tribunal may consider issues such as patent validity, but the outcome will not result in revocation of the patent. And even if the tribunal finds that the patent falls short on the patentability criteria set out by applicable national law. Despite such restrictive approaches, of course, there are also jurisdictions recognizing the arbitrability of all patent disputes. For example, that's possible in the United States and Switzerland. And so having said that, I think it's a good coverage for the issue. And I would like to give the floor to the next speaker.
Thank you, Natalia. That demonstrates that IT and IP is one of the critical subject matters if we talk about arbitrability, and that the approach is really variegated around the world. Reinmar, can you please tell us if IT and IP subject matters are arbitrable in Germany?
Yes, of course. Thank you. So starting from the liberal and permissive approach of 1030, first paragraph of the German Code of Civil Procedure, one has to see that most IP-IT disputes indeed refer to claims involving property rights. So the general rule is, yes, they are fully arbitrable. There is a dispute only to the extent that Natalia has already mentioned, and that is patent disputes relating to the declaration of invalidity, revocations, and compulsory licenses. So some say they are not arbitrable at all. Some say the effect of such arbitrations is limited, as set out by Natalia. Thank you.
Okay, so again, care is needed when we talk about arbitrability of IT and IP issues in Germany. Stelios.
Yes, Mr. President. Intellectual property issues can be divided into wide categories. First is the intellectual property right on the merits. So in these kind of cases, like disputes between the holder of the right and the licensee or the franchisee, yes, according to the liberal view of the Greek legislation, it can be arbitrable and can be resolved in front of the Greek courts. There is a very important exemption here, according to Article 124 of Regulation 2017-1001, European Union trademark courts are exclusively competent for trademark disputes concerning infringement and challenge of the validity of trademark. So in that case, there is only in that case there is an exemption, which is very strict and exclusive. In all the other cases, the European courts are the European arbitral tribunals are competent to resolve these kind of matters. However, there is the second category, the administrative disputes concerning the infringement or the validity of the patent or the trademark, which are resolved by the trademark offices or the patent offices. And those cases cannot be arbitrable because they have an extensive administrative nature. And lastly, concerning the most important issue about those cases is whether the owner of the right has the possibility to dispose freely the right. So in that case, according to the Greek legislation, the arbitral tribunals can resolve those kind of disputes.
Thank you, Stelios. So I understand that IT and IP matters when they interfere with administrative courts or rights are an exception to the very liberal approach that you have in your law on arbitration, which is
exactly.
And we were just trying to address all these particular issues that can fall outside liberal and wide provisions in the national laws on arbitration. Before she leaves, Natalia, I would like to ask you if you had some experience with WIPO, and if so, if you just tell us briefly what is WIPO, because it's strictly related to what we are discussing.
Of course, and of course, as every lawyer practicing intellectual property law and IT law, I'm familiar with the WIPO Arbitration Mediation Center. This is one of the arbitration institutions dealing with IP disputes in particular. And my experience is that WIPO is covering equally both arbitration and mediation of such disputes. I had a pleasure to be a part of the proceedings. The quality was impeccable. However, I have to say that the quality of other international arbitration institutions, of course, is not lower, while the WIPO is, of course, specialized, focused in the area institution.
Okay, and would you suggest to go to WIPO to settle a dispute on IP issues?
I think, Jacopo, of course, it makes sense. I'm not restricting the IP disputes to WIPO Arbitration Mediation Center competence only. It's not the only forum available. However, I have experienced cases both where the case was brought to the WIPO Arbitration Mediation Center on the basis of the arbitration clause, which was a part of the contract, and also on the basis of the submission agreement, where the parties simply have decided that now they don't have time and money to go through cross-border litigation, and they wanted to have the dispute resolved now and finally. Therefore, I think it's true that cross-border IP litigation is extremely costly, and therefore arbitration is always a very, very good solution. I never stop repeating it to the clients.
Thank you, very helpful. Gailė, IP and IT disputes in Lithuania.
Yes, thank you. So very similar to what Stelios talked about, Lithuania excludes from the remit of arbitration disputes the sort of administrative part of IP-IT disputes, so specifically stating that registration of patents, trademarks, and designs cannot be arbitrable. So commercial disputes, contractual disputes over or relating to other matters in IPIT can be arbitrable.
Thanks. Roberto is absent for the moment. Przemyslaw for Poland.
I'm here, Jacopo.
Okay, so Roberto, I'm following the alphabetical order of the states. So Italy is before Poland, and so Roberto, please go ahead.
Oh, thank you, Jacopo. I would say that Italian law in this area had an evolution very similar to that we had in the United States, and which was mentioned by Jacopo at the beginning of our webinar. As a general rule, now IT and IP disputes can be decided by an Italian arbitral tribunal, but only provided that the parties do not require a decision capable to have effects also on third parties, such as the declaration of invalidity of a patent. And so the situation is very similar to what was indicated by Natalia and Reinmar.
Thank you, Roberto. Przemyslaw, Poland.
Let's say, in general, no difference to what was said before by my colleagues. So generally, all the administrative issues, validity, annulment of patents, of trademarks, etc., those are just, let's call this restricted areas. All the disputes relating to license agreements, to the usage of IP rights, they are just fall within the scope of the arbitration as property-related rights. Maybe two interesting things just to mention, that we have two major arbitration institutions in Poland. One is called KIG, and they have just the special or separate rules for domain disputes. They are just the internet domain disputes, but this shows that at least at the certain point of time, this was a market for this type of settlements. And also recently, the other court, which is called Leviathan, has established the separate, or maybe not separate, but specialized arbitrators, recommended arbitrators list for film, for movie disputes, copyright disputes, and all these type of intellectual property. So again, this is indicating that you have from time to time the certain areas of the market that are developing, and this last one is pretty active at the moment in Poland.
Thank you. Nazareth, what do you say for Spain?
Thank you, Jacopo. Spanish Arbitration Act applies a subsidiary to the laws containing in a special provision on arbitration, and this is the case of intellectual property matters that is recognized in Article 158 of Royal Legislative Decree 1996, and later on different promulgations. So in general terms, submit to the limit of time, arbitrability of IT and EP dispute are arbitrable, and regarding EP matters under Spanish law, arbitrable patents dispute concerning the infringement of patents, patent validity, and patent licensing can be arbitrated, provided that both parties agree to arbitration. Trademark also are arbitrable, copyright, trade secret, licensing, and technology transfer agreements also, and related to IT dispute are arbitrable. As example, software licensing, outsourcing agreements, e-commerce, data privacy and protection, and cybersecurity also. Thank you.
Thank you, Nazareth. Natalia, do you have another couple of minutes?
A couple of minutes, yes.
Okay, so now we switch to another very important subject matter because it interferes with the direct investments in a country. So I'm talking about public works, and the case is very practical. If a foreign investor comes to, let's say, Russia, if you can tell us about Russia, for a direct investment, and the owner, the employer, is a public entity, is that it is allowed to settle disputes through arbitration?
Of course, Jacopo, it's in practice, the disputes on the recovery of losses under an investment contract concluded, for example, with the municipality, disputes from legal relations on the list of forest plots, from the contract of pledge of state-owned real estates, from contracts related to activities in special economic zones were recognized by courts as non-arbitrable. Also, disputes arising out of relations under contracts concluded to secure state and municipal needs were initially recognized as non-arbitrable at the level of law. However, then the law defined arbitral institutions, that arbitral institutions are authorized to administer arbitration of disputes arising out of such contracts, so that disputes could become arbitrable. However, the law says specifically that, for example, disputes arising out of relations regulated by the law on privatization and disputes arising out of relations regulated by the contractual sphere in the state procurement are not non-arbitrable. It's like area where I think the trend is that the disputes are considered as non-arbitrable.
Thank you, Natalia, and thank you very much for your time. Reinmar, again, talking about practical examples. If I am a construction company and I want to execute a work in Germany where the employer is the Ministry of Transport, is it possible to settle disputes in such a construction contract by arbitration?
Yeah, thank you. So the answer is pretty straightforward for Germany. Those claims refer or relate to property rights and are fully arbitrable. So there are no limits under German law. Thank you.
Very clear. Thank you. Stelios, for Greece.
Yes, Mr. President. In Greece, there was a very long-standing tradition that administrative disputes are arbitrable. It started since 1993 when Supreme Special Court held that arbitration in administrative disputes is not against Greek constitution. So after that, and came the new International Arbitration Law 2023, which allows explicitly the administrative disputes to be arbitrable. From this general rule are exempted those disputes that include the cancellation of administrative acts, where a legal or a natural person turns against Greek state to cancel an administrative act cannot be arbitrable, and it should be referred to the administrative court. Also, it is important to stress that the administrative courts have the right to ignore, let's say, an arbitral award in case this award is against public order. So in that case, the administrative court can either ignore or obiter dictum say that this is unconstitutional or against public order award. So investors that would like to invest in Greece can have the possibility to conclude a clause, an arbitral clause with the concession agreement with the Greek state, but always should take into account that the subject matter of this agreement should be freely disposable, and the investor can freely resort to arbitration. And if we have the time in the end, we have a Greek Achmea case, as I told you before, I mean, in the previous meetings, which is commendable, commendable in the sense that came another rock on this cohesion of cases, Achmea LP Holdings, PL Holdings, and common story, and now probably this case is not very visible on the European level, but we should comment it. Thank you.
Thank you, Stelios. Gailė for Lithuania.
Yes, so thank you. In Lithuania, the disputes arising from public works are generally arbitrable. I will mention two nuances. So the first one is that the courts explicitly exclude the disputes over public procurement tender procedure. So anything that relates to the tender itself, how the tender was organized, the results, the assessment, that is non-arbitrable. The second nuance is depending on who the public entity is that the agreement is concluded with. The entity may require a permission from its founder of that public entity under Part 3, Article 12 of the law on commercial arbitration. So essentially, some public institutions and publicly owned companies, so state companies and municipal companies, require an agreement of their founder to conclude an arbitral agreement. Again, one interesting nuance to this is that the courts do not allow such companies to invoke this prohibition internationally. So if there was an international contract and the entity, that the Lithuanian company, a publicly owned company, did not obtain this permission, it cannot invoke this as being non-arbitrable.
That's very innovative. That's very interesting.
So and it's purely case law and on the basis that it would be unfair. The motivation of the court just said it would be unfair.
Okay, because I would like just to remind that for public courts there are interferences from this Achmea jurisprudence, interferences from the fact that one of the contractual parties is a state entity or public entity, so sometimes they are not allowed, they're not capable to enter into an arbitration agreement, and there are also public order issues. Roberto for Italy.
Thank you, Jacopo. So it is really interesting, I think, to see how the relationship between arbitration and public works has evolved in Italy. This is because every now and then arbitration is either the preferred dispute resolution mechanism or, to the contrary, is strictly forbidden. Currently, we have a specialized arbitration center dealing with public works. And in addition, there are some peculiarities concerning the claims that the contractor is entitled to raise based on the distinction between proper rights and legitimate interest, Italian interesse legittimo, which is really complex, really Italian specific, and therefore falls outside the scope of this webinar. Nonetheless, as a rule of thumb, it could be said that, as Gailė just told us, it happens in Lithuania, also in Italy, disputes concerning the administrative, the procurement phase are not arbitrable, while are arbitrable the disputes concerning the contractual relationship between the public body and the contractor and the fulfillment of their respective obligations.
Okay, Roberto, you mentioned an arbitration center for this kind of disputes. Is that a private organization or a public one?
It's a public organization. It's controlled by a public body.
Okay, thank you. Shenko?
So generally, as Poland is concerned, again, we can just divide this into two stages. The first one is just the public procurement phase, which is any claims or disputes relating to this one are settled by, let's call this the special body. The translation would be National Chamber of Appeal. So this is at the phase of getting the contract. When it comes to the contractual relationship and the execution, generally this is arbitrable. Interesting point, I would say probably two interesting elements. The first one is that in at least a large number of procurements, you are getting the draft of the contract where the jurisdiction clause is already inserted, and this is usually difficult to negotiate. So whatever the employer is choosing, then it goes through, and it depends on the type of the contract usually. If we are talking about the options, in fact, you have three. The first one is of course common courts. The second one is a kind of, it's an arbitration court, which is which is affiliated to what is called the General Council to the Republic of Poland. And this institution is the public one. Is in principle, it's a big law firm which is servicing all the state and the state-owned entities from different perspectives. So sometimes it's claimed that it's too close to the employers, public employers. And the third option is, let's call this the standard arbitration, like ICC or Polish arbitration court or whatever, depending on the situation. So probably these are just the peculiarities or specifics of the Polish approach to arbitration of the public works. Thanks.
Thank you, Shenko. Nazareth. What about Spain?
Okay, for Spain, in this moment, if we talk about employment arbitration concerning Spanish Arbitration Act is not applied because employment arbitration is subject to special legislation and
Nazareth.
Spanish arbitration.
Nazareth, sorry.
Yes.
This is on public works, construction works.
Okay, I know. I want make a disclosure regarding employment arbitration.
We're going to talk about employment later, right? If you like.
Okay. So regarding public works, it is established in a special provision of the modification what came into force in Spanish Arbitration Act in 2011, and it is permitted public from state arbitration, specific arbitration with entities which are working with the state. So it permitted, but it depends on the arbitration clause regarding matters. Thank you.
Great. Then thank you. Now we switch to another matter, which is traditionally discussed if it can be submitted to arbitration or not, which is family matters. And so I would start again from Reinmar. Has there been a development in Germany concerning arbitrability of family matters?
Thank you. So actually no development, but a very clear distinction. So the distinction is along the lines, is there a property right involved, yes or no? And in status proceedings in family law, like matrimonial, parentage, or adoption matters, including child custody, there is no property right involved, and the parties cannot settle such disputes, so they are not arbitrable. Anything else, in particular claims for maintenance, relate to a property right, and they are arbitrable under German law. Thank you.
Okay, and that is deductible from your section 2013.
2030, first paragraph, right?
Yeah, good, thank you.
But it doesn't develop, so it's been there from.
Okay, because yes, this is something that it is developing, of course, with a trend to allow the parties to arbitrate family matters.
Yes, right, but it's very clear cut at this stage. Thank you.
That's easy. Stelios, in Greece.
Yes, in Greece, family matters traditionally are outside of the remit of arbitration, and this is due to the fact that these are issues that they are not freely disposable, and they are not freely disposable because they concern public order matters. For instance, the divorce concerns the sanctity of the marriage. Issues of custody concern the protection of the nuclear family. So in that sense, being issues of public order cannot be disposed freely and cannot be therefore arbitrable. However, according to the new tendency of the new international arbitration law, in case parties agree to apply in a dispute the new law, which is the international concerns international matters, and to set aside the domestic law, then issues like alimony or child support or division of the common the property acquired during the marriage, then and in general issues of pecuniary nature can be considered arbitrable. So if two parties waive from the domestic protection and agree to arbitration, then on purely pecuniary issues can resort to arbitration.
Thank you, Stelios. Gailė?
Yes, so Lithuania is very strict on this, that the one probably place where it's completely excluded out of arbitration remit. And it's considered of significant public importance to exclude both monetary and non-monetary matters in any way related to family matters.
Thank you. Przemyslaw?
I think the same as my colleagues said, strict delimitation, any marital status, guardianship, care, custody matters are just excluded. Any financial matters could be just subject to arbitration, but alimony, which is the exclusion, which is spelled out directly in our civil procedure code, as I mentioned at the very beginning. As far as justification is concerned, it's just the public interest which justifies this approach. As far as developments are concerned, probably not quickly anything would change. Thanks.
Thank you. And now Nazareth, who is, by the way, an expert on family methods and even on mediation of family methods. And it is pretty curious that as far as we see, family methods are not generally arbitrable. but mediation is very popular for these disputes. Of course, with an arbitration, you get a decision which is assimilated to a state court decision. Mediation is to help the parties to agree on a solution. But yes, Nazareth, you briefly mentioned something about family matters earlier, but could you please develop a little bit more?
Thank you. Family matters, as mentioned my German panelist, is practically similar. Family matters are not arbitrable, but financial matters concern family matters are arbitrable. In fact, family matters in Spain maybe is a common trend that we try that go to mediation or even negotiation between the lawyers if the lawyers are highly qualified, always are highly qualified. I means that arrive to a mediation in family matters is quite difficult and implies capacity for the defense of the parties concerned. Anyway, it's not in this moment, and maybe take time for other seminar.
Okay, thank you. And now Italy, because I'm also Italian, and I've seen over the past couple of years meetings, conferences on arbitration of family matters, but I'm afraid there isn't a tangible development in this country. Roberto, could you please inform us?
Yeah, thank you, Jacopo. I would say that in Italy, it depends on the specific claim and the party's request, because the decision concerning the status, so separation, divorce, etc., is reserved to the state courts, and no exception is allowed. I mean, there are some ADR mechanisms provided for by specific law rules, but not arbitration. A more liberal approach could be taken with respect to in general, the economic claims within the parties, and as you mentioned, some practitioners are trying to explore the capabilities of arbitration in these matters. But I am a bit skeptical, and for this reason, these matters, the arbitration clause has to be made and signed where there is already a dispute. And when there is already a dispute in family matters, it is very unlikely, I think, that the parties are able to find an agreement even on procedural matters.
Thanks. Thank you. Now, before switching to another matter, I would try to allow one of our participants to speak because I see a raised hand, Zafar Kalanauri. I will try. I have a button here, and if you want to intervene, you're very welcome. So you might try to activate your audio, your microphone. Okay, Zafar?
Hello.
Yes,
hello. Yeah, can you hear me?
Yeah.
First of all, I feel very much enlightened by the panelists who are just fantastic and they know what they are doing. I have a question. When you talk about arbitrability, there is now a popular concept around the globe, which is composite mode of resolution of disputes, where part of the dispute is resolved through mediation and the rest of it is done through arbitration. I was wondering that this kind of thing is being used in Europe, where you resolve disputes partly through mediation and the rest of it through arbitration.
Yeah, that's very common, and there are some sectors, business sectors, where it is very common to have this multi-tiered clauses where parties are required to attempt some alternative methods before going to arbitration, and some others where this procedure is not so common. So as we said, for example, in family matters, parties are allowed and are encouraged actually to use mediation, but they are usually prevented from arbitrating the dispute. Let me give you just an interesting and very particular example of what is happening here, for example, in construction law. Now it is compulsory for the parties, the owner and the contractor, to go through a kind of dispute board procedure. And within the dispute board procedure, which is in the middle between the mediation and arbitration, in that procedure, the dispute board can even issue a kind of expert determination. And then if things are not settled, there will be arbitration or state court. Anyway, it is very common to see these different methods together where there is a contract. Does that answer to your question, Zafar?
Thank you so much. I was just wondering, when you talk about dispute resolution board, especially in regard to construction disputes, what is the constitution of this board? Who are the people who man these boards?
What the people who are in these boards, you mean?
Yes, yes.
Okay, now I'm going to answer, but probably Shenko has something related to what we were saying earlier. Shenko, am I right that you were raising your hand?
Just go first.
Okay, no, at present, I think there should be some criticism on the way the dispute board members are appointed, because the parties are allowed to appoint a member among their employees. So that is in full conflict with impartiality and independency. In spite of that, things are working better now in public works in Italy, because as it happens with dispute boards, many small claims are settled before they become too difficult. So appointment is made by the parties, and then there isn't a roster as I would like to see in the future. So usually the two appointed dispute board members have to select a chair.
But I would like to remark, Zafar Kalanawiri, that previous dispute boards, what is important is elaborate, drafting the contract, and in this public works contract is important in the very beginning, the prevention, and I consider your question is very important. It's not the matter concern due our limit of time, but I'm afraid that we need work in this dispute board, and you know that here in FCIArb we have rules concerning dispute board, and also we have other type of dispute resolution, and it is adjudication that maybe we can provoke another seminars. But in resume, the most important is drafting an adequate public works contract that involves this escalation clause regarding expert determination, as dispute board refers, and go later on maybe mediation or maybe arbitration as the last state of the escalation of the conflict.
Okay, thank you
so much. Thank you so much.
Going back to the core of our webinar, please remember that, for example, in this case, in public works, parties are allowed, actually are compelled to use dispute boards, but they can't arbitrate thereafter the dispute. If they are not able to settle in that phase, they have to go to a state court.
That makes sense.
Yeah.
Maybe just general comment, because as I understood, the Zafar question is whether these are used in the jurisdictions and in what sense. And I would say that I would divide this into two sections. The part one would be the typical, let's call this multi-jurisdictional clause. When you are going for mediation, you are going for negotiations, and finally you are going for the arbitration. And the other one is MedArb, let's call this Chinese way a little bit, which is a totally different creature. And I think I will not elaborate on that, but I would say that, at least to my understanding, this is not very popular, say it mildly, in the European contents. So because this is cost of issues relating to the independence and all these kind of elements. So just additional comment. Thank you.
Thank you, Przemyslaw. So we are close to 11:30, which is the established time for this webinar. I would like to discuss a bit further, but if some speakers have to leave, probably some others can stay for another short round of questions. Are you all available to stay other 10 minutes? Otherwise, okay. So
I must leave.
Sorry?
No, I must leave. So sorry, and thank you very much.
Okay. Thank you very much for your help, and see you in the next webinars.
Thank you.
Thank you. I had just some remaining points in my list on which I was interested in understanding better in each different country if they are arbitrable or not. These matters are insolvency, employment, corporate law, and trust. Some of these are pretty difficult. Insolvency and corporate law is difficult to give a straight answer in a few seconds. The last webinar, as I said, was on comparative corporate law, so the attendees can make reference to that one. On insolvency, is it possible for you to just tell if is included in your sources the national law, or if it is expressly excluded? Reinmar.
Yes, arbitrable.
Okay, Przemyslaw.
Generally, I would say not, depending what you mean, because the arbitration, from my perspective, the clue is what's going on with the proceedings and what is the validity of the arbitration agreement if liquidation or insolvency occurs. And this is, let's say, the host of rules which are pro-arbitration, I would say, from a couple of years at the moment, but liquidation is subject to the common court, and but this is administrative part as well.
I see. Gailė.
So very similar. The proceeding of liquidation itself, obviously not arbitrable, but the courts maintain that all arbitration agreements that have been concluded before insolvency occurred are fully enforceable, but the company cannot conclude new arbitration agreements.
Good, makes sense. Stelios.
The Greek international law, arbitration law, includes a specific paragraph about this matter, saying that bankruptcy or insolvency proceedings shall have no effect on an arbitration agreement unless the law otherwise provides. Here we have it again a little bit, it's a delicate issue, because at least in Greece, bankruptcy has two dimensions. One is the measures that they are personally addressed to the insolvent person, who has some restrictions like a ban to transact, or sometimes it is put in jail, etc. So those matters that concern the personal condition of the insolvent person are not, of course, arbitrable. On the other hand, the financial issues of the bankruptcy concerning the financial condition of the company, issues of restructuring of the company, or finding measures to protect the creditors' rights, can be, according to this paragraph, can be arbitrable. Also, there is another dimension, whether after the bankruptcy, the receiver of the bankruptcy or insolvency, whatever is the terminology in each country, whether the receiver has the duty to continue in the arbitral proceedings that have started before the judgment on bankruptcy. So in that case, according to Greek law, the receiver does not only have the discretion, but has the obligation to continue the arbitral proceedings that have started before the bankruptcy. So I think that in that way, it's a pro-insolvency legislation ensuring the rights of the creditors and a sound evolution of a company that is under restructuring in the context of the insolvency regime.
Thank you, Stelios. And finally, Roberto, what do you think?
Jurisdiction over insolvent parties is a core function of state courts in Italy. But I would say that a good rule of thumb is that when the insolvent party is the claimant, arbitration is possible. When the insolvent party is the respondent, arbitration is not possible. Nonetheless, this rule of thumb may have some exceptions in case of cross-border insolvency under the EU insolvency regulation, which follows a Westphalian approach, as the late Professor Gailė would have said, and therefore allows arbitration if it is so allowed by the law of the seat. I would mention that the IBA has just published a toolkit on this really matter, and I had the opportunity to write the chapter concerning Italy, concerning my colleagues Fabio Santacroce and Giovanni Profazio, who is also the chair of the Italian chapter of FCIArb. And maybe we could share the link with our attendees together with the other materials of the webinar.
Thank you, Roberto. And yes, that leads me to say that we want to be available for future questions, direct questions to the speakers, because I'm afraid we are not going to respond to most of the questions. And I'm not sure that the attendees have our email addresses, but I will make sure with the head office that that will be possible. I'm not able to access the chat of the attendees, so that will be made at a later stage. Now, employment law, that's another very debated subject matter in terms of arbitrability. Reinmar?
Yeah, thank you. So there is well, it's one of the questions with an answer that is not that easy and that straightforward. Generally, employment matters are excluded from arbitrability, with some exceptions, and they are stated in Section 101 of the Labor Court Act, and they are essentially disputes between parties to a collective agreement. So unions on the one side and employers on the other. Yeah, that's the first exception. And the second one is individual employment contracts in the area of artists, filmmakers, and jobs like these. So that's very narrow, those exceptions, but generally arbitrability is excluded.
Okay, Shenko.
Generally, if we are talking about standard employment contract, no, unless the arbitration clause is signed or arbitration is agreed post-dispute. So it means that you may have a compromise, but not the arbitration clause in your employment contract.
Thank you, Gailė.
So Lithuania has the exact same provision, arbitration only possible if the agreement was concluded after the dispute has arisen.
Good. Stelios.
The general idea of the employment contract is that the negotiating position of the parties is unequal. Employees in a much inferior position vis-a-vis the employer. So in that case, the protective measures that they are adopted by the national legislation should not be circumvented. However, according to the new clause of the Greek law, according to the presumption of the arbitrability, then the employment contracts are open to arbitration. However, I would say that protect the arbitration in employment contracts is permissible on conditional upon not circumvention of the protective measures of the employees, because otherwise the labor law is completely undermined. Sometimes in some the athletes, for instance, that they have employment contracts, it has been considered by the Greek courts that this is a lawful clause. The athlete contracts are subject to arbitration. When the classical worker has no this possibility or has no this disadvantage, let's say that this is more correct. But if comes a foreign company and wants to circumvent the employment law, the only way is that adopting this permissive clause of Article 3.4, the presumption of arbitrability, to adopt it so as to bypass the Greek employment law, which is really very strict, and it was just made for protecting the inferior position of the labor class and the people that they are employed by business, and they need those restrictive measures, and one of those measures is a non-arbitration clause.
Thank you. Roberto, for Italy.
In Italy, it is allowed in theory, but very uncommon in practice. And the reason is that it is allowed by Italian law only if it is allowed by the relevant collective agreements. And usually the collective agreements do not allow it. There's also a fun fact which is referred to in the flyer of the webinar, and it is that under Italian law, the agent-principal relationship is an employment relationship if the agent is a natural person, and the consequence is that arbitration in these cases is not possible.
Thank you. And I do stress that this is a problem also for state court jurisdiction, because for employment disputes, most of the times the employee is allowed to litigate also in his or her own country. Okay, if you have another minute, a couple of minutes, I wish to address also something on trust. I'm saying that probably most of you haven't had any direct experience with, for example, arbitral agreements in trust deeds, but the ICC proposes a standard clause for trust disputes. So I'm not asking to all of you in turn which is the situation for trust matters, trust disputes, but I'm asking if some of you have something to say on this particular subject matter. Cenko.
So generally, let's say no trust under the Polish law. We have recently a creature, let's call this, which is called Family Foundation. which goes into direction of managing the wealth of family of persons, so similar to the trust fund in the common law. This is interesting that we have also the regulation which is allowing, or sorry, starting from a different angle. This is the corporation, or this is just the registered entity. So it's different than the trust when the owner of the wealth is the trustee. So this is more common to similar to the corporation or to the joint stock company. And interesting enough, and this relates to this seminar, if you have the disputes relating to both corporate matters and these family foundation matters or any associations nowadays, this could be arbitrable. There are certain conditions, not probably time to comment on that, but probably interesting to know that something like this is developing in my country. Thank you.
Other comments?
Jacopo, I would say that I don't see any reason why a dispute concerning a trust cannot be decided by an arbitral tribunal seated in Italy. And such a dispute could even concern the mere existence of the trust. For instance, if it is a trust under the Hague Convention, where the sole non-Italian aspect is the governing law. But this point would concern the merits, and an arbitral tribunal in Italy would be able to issue an award on the merits, even if the contract, in our case the trust contract containing the arbitration clause, is null and void under the separability principle.
Yeah, you're right. And no, the question is that in most of the cases, if there is a dispute within a trust, is a family trust and family matters interplay with the resolution of disputes. Anyway, just to give you a useful comment, this issue about arbitrability of trust disputes is carefully examined in the common law countries, England and Wales, Jersey, Guernsey, where they are adverse to grant arbitrability for this kind of disputes, because they say in those countries the state courts are so proficient on this kind of disputes that dispute shouldn't go to arbitration. And we might say even the opposite in other countries where the trust is not part of the tradition. If a trust dispute goes to a state court, it is more likely that the judge is not that familiar with this kind of things, while of course an arbitrator could be selected among those who know how the trust deeds work. If you don't have other comments, I might go for a quick closing remark. And then it's about the questions. I've read the questions. Some of them are rather complicated, and I will invite you to write to some of us to get a direct answer. Just one question is very easy. Is whether the matters pertaining to the injunction is arbitrable. I would ask to attend one of the next webinars, because this pertains to interim measures, to the power of the arbitrators to grant injunctions or other urgent or interim measures. So I'm sure that it will be discussed in the next webinar. Just let me say that we didn't go through another important part of arbitrability, which is the evaluation of an award which is connected to a subject matter that is arbitrable in a certain country, but when the award is brought to another country, it could happen that in that country that very matter is not arbitrable, and so there is an issue if a dispute settled by arbitration is can be recognized and enforced in other countries where that matter is not arbitrable. But again, for this, we have the last seminar of this series, so I'm sure that it will be discussed in that occasion. If the speakers don't have any other comments, I think we can close it here, and I thank you very much for your extremely professional and careful examination on these issues. Okay, so thank you very much, and see you in the next webinar of this series.
Thank you.
Thanks a lot.
Yeah, thank you.
Thank you.
Thank you. Bye.
Bye. Bye. Bye.